Yes. Your Honour, the defendant calls its second factual witness, Mr. Antoine Socon.
Please state your name and your address for the court.
My name is Antoine Socon. I live in Dubai Silicon Oasis. I swear by Almighty God that the evidence that I am about to give is the truth, the whole truth, and nothing but the truth.
Thank you very much, Mr. How do I pronounce your name?
Socon.
Socon, okay. Please sit down. Thank you. Make yourself comfortable and but keep your voice up if you would.
Definitely, Your Honor.
Thank you. Yes. Volume 2 in front of you. Tab 15. And that is your first witness statement dated 31 January 2016.
Yes, indeed.
Back of the documents.
Yes, indeed.
Please can you confirm that that witness statement is true and accurate to the best of your knowledge and belief?
Indeed, yes. This 18 or 19? My second witness is tab 17.
Tab 17.
Yes, indeed.
Second witness statement dated 11 January 2017.
Yes.
Can I ask you to turn to page 367? Can I ask you to confirm that that is your signature?
Yes, indeed.
Finally, can I ask you to confirm that that witness statement is true and accurate to the best of your knowledge and belief?
Yes, indeed.
Thank you. Mr. Thomas, I have some questions.
Mr. Socon, good afternoon.
Good afternoon.
Could I ask you to be shown file 9, please? Tab 137. And we can see there that's the invitation from Mr. Hall of E.C. Harris.
Sorry, if I may, 137?
I'm sorry, 127. 27. Were you in court earlier when Ms. Schrocker was giving evidence?
Yes, I was present.
Right. So did you hear her answer my questions about a meeting that took place on the 10th of August?
Yes, I did.
Do you recall if you attended the meeting on the 10th of August 2014?
No, I didn't attend that meeting. In fact, I was on leave on that period,
You were on leave?
during that period.
I mean, I can show you the same documents as I showed Ms. Schrocker, but it looks like someone attended for the bank. If it wasn't you, I mean, Ms. Schrocker said it was either you or her were the people responsible for attending meetings such as this. So who do you think attended for the bank?
I cannot know. However, yes, indeed, it's either me or Miss Alia who attend usually.
Sorry, it's either you or?
It's either myself or Miss Alia who usually attend those meetings.
Ms. Alia being Ms. Schrocker?
Yes.
Yes, it's usually either you or her.
Or E.C. Harris.
Yes, but this was a meeting, we've seen documents that suggest that the bank itself attended as well as E.C. Harris.
I presume this is what is said, but I'm not aware of the fact that someone from MBAD attended this meeting.
Do you want to see the documents that suggest that someone did attend from MBAD? We can see at 127-1776 that a meeting was required to include NBAD. And if you go on to 1820 in this bundle, it's an email from E.C. Harris in September, and point 2 towards the bottom of the page, as per the meeting on site with NBAD, and that's an E.C. Harris on the 10th of August. Says E.C. Harris recording that the bank attended the meeting on the 10th of August 2014.
If my understanding is correct, it says, as per the meeting on site. Honestly, I cannot comment on this.
Well, you can't comment on the meeting if you weren't there. Of course, I accept that. But somebody, it appears, attended the meeting on behalf of NBAD. And the two people who got the initial invitation were Ali Ashoka and yourself. You were away. So does it follow that it's Ms. Shoka, in your view, who would have gone to the meeting?
I can't confirm this.
Was there anyone else responsible within the bank for attending meetings such as this?
Usually not, because at the end of the day we are managing this account.
You and Ms. Shoka?
Yes.
Yes. Now, can I go on then to deal with events that happen after the reinstatement agreement is put in place on the 28th of September 2014? It's right, isn't it, that you made a report to the chairman in October 2014?
I presume yes, if I can refer to...
Let's have a look at it in bundle 10, please. Look at page 153. Oh, tab 153.
Sorry, that's tab number?
Tab number 153.
I have here an email from Ms. Alia. That's the reference here.
If you go to this next page of it, it's case submittal form to the chairman's office.
Yes.
And now this is a document that you were aware of at the time?
Yes.
And prepared or helped prepare?
Yes.
And this is an update on the position of the DAS real estate project as at 12th of October, isn't it?
Indeed.
And if we look towards the bottom of the page under key issues, we can see the second bullet point from the bottom, potential slippage of completion date to August 2015 from March 2015.
Potential, yes.
Yes, that's what you were reporting to the chairman at that stage. And I just wonder where you got the date of August from, Mr. Socken.
I'm sorry, I cannot recollect.
Okay. Well, what you did have by this time was a report from E.C. Harris, wasn't it, just a few days before?
Yes, yes.
Let's see what you said in your witness statements about that, because you made a correction in your second witness statement from your first, didn't you?
True.
Bundle 2 at your first witness statement, Spider 15. page 313 of the bundle. Do you have that? Page 313.
Yes.
This is your first witness statement, and you said at paragraph 18, in any event, it was not until much later, in about early December 2014, when we received the E.C. Harris report, that it was confirmed that the completion date of 31st of March 2015 was no longer viable. That's what you said in your first witness statement, and then you very fairly corrected that, didn't you, in your later witness statement, paragraph 25. Go to page 351 of the bundle. You said, paragraph 18 of my first witness statement, I state that Harris confirmed the completion date of 31st of March was not achievable in about early December 2014. This paragraph should be corrected to refer to 9th of October and the E.C. Harris monthly report that's described below. So it was in fact 9th of October 2014 that you realised that the date of 31st of March was no longer viable.
Indeed, yes.
That was your understanding, therefore, then from the 9th of October onwards, that that completion date was not viable.
From that date onward, indeed, there were a risk of non-completion of the project by the
I'm not sure I'm quite following this, forgive me. The E.C. Harris report on the 9th of October is where?
The Harris report, 9th of October, is at 10, file 10, tab 152. What we've looked at is Mr. Socken's two.
Yeah, I just wanted to see what, not easy to remember everything that's written.
I was going to go to the report next.
Yeah. Well, maybe I can just answer since I interrupted.
Yes.
Yeah. Would you help me with your memorandum at Bundle Chan, divider 153, page 2105, when you refer to a potential slippage of the completion date from August to March?
Yes.
I think you were asked a moment ago where you get those dates from.
Yes, Your Honor.
Can you remember where you get the August date from?
Usually, Your Honor, we refer to the E.C. Harris report, which is our surveyor now. In this particular instance, I presume that it came from there.
When you were considering the Harris report and the extent to which they were concerned about potential slippage, what did you understand to be the criteria for making an assessment of when completion would take place? Did you assume that the criteria were that there would be an efficient, fully manned, fully planned construction operation? Or were you thinking that there was the impact of the ongoing dispute, the lack of sufficient resources, the minimal resolution, and so on? So what are you contemplating as the criteria here for making an assessment as when the matter would be finished?
Your Honor, I wouldn't be able to determine a date in terms of completion. I would rely on the E.C. Harris.
Right.
Input.
So whatever criteria E.C. Harris had, you would adopt that inferentially,
Yes, Your
without
Honor.
knowing what they were.
No, we would know what they are
Okay.
because they would be around
Oh, we may have
usually
to look at that. Okay, thank you
technical
very much.
and
Right.
So let's look at the Harris report that you had on the 9th of October. Then that's in tab 152. This was the Harris report for August, which you received on the 9th of October, wasn't it?
Yes, indeed.
And if we look at page 2082, and we can see that they explain why it's been issued late. And the second line, this has been issued late due to the late receipt of the Hill International monthly report for August, September, followed by the Eid holiday. Then programme and progress. The contractor's programme has yet to be accepted by the project manager and engineer. It has a completion date of 31st of March 2015. Until the outstanding design issues are addressed and the nominated fit-out subcontractors issued, finalisation of the construction programme will not be possible. The programme doesn't include the installation of furniture, fixtures and equipment and operating supplies and equipment. The project manager has been requested to provide a master programme capturing the above. This will provide NBAD with a realistic overall project completion date. The manpower throughout August fluctuated between 250 to 300 per day, which is considerably below the project manager's estimated required amount of 850. Contractor continues to avoid initiating any acceleration of works or application of additional resource beyond these existing levels. Then the interior design packages have not yet been awarded. The project manager has confirmed the packages need to be awarded in September if the 31st of March 2015 date is to remain viable. This is a significant programme. Landscape consultants and acoustic are to be appointed. Design scope gap review has been undertaken. And third-party approvals and Akil are yet to approve the cooling tower, and non-approval could significantly impact the programme. Based on the above, it's our assessment that the current reported project completion of 31st of March is not achievable. And it was that, I think, that led you to say in your witness statement, Mr. Sokon, that the 31st of March date was not viable. That became your understanding from that date.
Yes, indeed.
And we can see that they're saying that the date is not achievable. But I just wondered where you got the date. I come back to that date of August that you were telling the chairman about just shortly after this report. You know what the source of the date of the slippage to August was?
I cannot recollect, but perhaps, Your Honor, through discussions after receiving the report from E.C. Harris, through talking to E.C. Harris, we might have received this feedback and we have incorporated in the report to the chairman to give a potential date. And if I may note that even under procurement, it says that the interior design package have not yet been awarded. The project manager has confirmed that the packages need to be awarded in September if the 31st March 2015 date is to remain viable. So basically, by that time, that award didn't happen, and accordingly there were the potential slippage.
Now let's see how this developed in the E.C. Harris reports. If you go on in this bundle 10 to tab 166, we pick up an email on the 3rd of December from E.C. Harris to yourself. That, dear Antoine, following your request, says Mr. Hall, the below will be captured in a separate summary within the monthly report. Please advise if you have any comments prior to inclusion. So is that right? You had asked for, what did you ask for, advance notice of the summary?
I wouldn't recollect exactly what were the circumstances. However, it might be that we needed to understand what's happening on site.
Let's have a look at what Mr. Hall said. It says this focuses on recent main contract requirements and not the overall project budget. General, the main contractor and its MEP subcontractor has become increasingly assertive and aggressive in nature in order to force the employer to accept and pay EOT amounts. This involves premature removal of site resources, placing procurement on hold until the EOT is resolved. Both could be deemed breach of contract. In order to attempt to progress the project and mitigate the delays associated with the drawn-out contractual claim determination process, the project team arranged a project principals meeting on 17th of November with IME and JLW. Present at this meeting, JLW verbally advised that it required closure on EOTs prior to committing to close out the project. So, a report to you that there's an increasingly assertive and aggressive contractor on site, removing resources and delaying procurement until its claims are resolved.
Indeed, as I mentioned in my witness statement, by end of 2014, it was apparent that there were a tension which was building between the project owner and the contractor, whether on the technical aspects or on the commercial aspects of the project.
And it was apparent from this report from E.C. Harris, wasn't it, that the contractor was not performing?
Well, it definitely says that he's not performing at the level required.
Yes. With this going on, with them removing resources from site and delaying procurement, further delay was inevitable. You would have understood that, wouldn't you?
Sorry, may you repeat the question, please?
With the contractor on site removing resources and placing procurement on hold, it was obvious, wasn't it, that there would be further delay?
Yes, there will be further delay if, yes.
And let's go on to see what the next monthly report says. If you go on to bundle 11, and this is tab 182. This is, if you look behind the covering email, you'll see that this is E.C. Harris's report for December 2014, which we can see was issued on the 25th of January 2015. And if we may look at the executive summary on page 2355, please. See now that the project manager has provided an updated master programme showing an anticipated project completion date of the 29th of September. This is a slip of 1 month from the November status, 27th of August. There is significant risk that the anticipated completion date will continue to slip due to the ongoing limited procurement and progress from the main contractor, the ongoing EOT issues and variations, and the continued lack of closeout of the identified outstanding design issues by the consultant team. Limited progress has been made throughout December. So things were going from bad to worse, weren't they, Mr. Sokhan? We're now projecting the end of September, and the projection has lost a month in a month.
Well, indeed, by January, and as I mentioned in my witness statement, the situation was actually deteriorating months on months.
At this point, at the end of January, with the completion date now projected at 6 months after the date in the restatement agreement, the date 6 months later than the date of the 1st of March.
Yeah.
We find in the documentary record no letters of protest to DAS about failing to meet or being likely to fail to meet that date of the 31st of March.
Well, obviously there were a lot of discussions with the project owner, Mr. Musabbah Nuhairi, in terms of discussing where we stand on the project and the delays that are happening on the project and the effect of those delays on the project completion date. And from a project finance perspective, our main risk was the completion risk. And obviously with the delays happening, this was discussed with Mr. Musabbah in order to find or to understand how he will be moving forward with completing the project as per the stipulated date.
There is, by the end of January, not a single letter from the bank to Mr. Musabbah to that effect, is there?
I cannot ascertain whether letters were sent or not, but I can ascertain that this was discussed in details with Mr. Musabbah.
I go to a document at in bundle 11, please, at tab 187. And this is another case submittal form to the chairman's office. And I think you tell us in your witness statement that you finalised this. Is that right?
Yes, indeed.
And these case submittal forms, chairman's office, does that mean they are submitted to the chairman's office?
Yes.
And again, this is an update, isn't it, on the DAS project? And we can see at the bottom of the page that there's the last bullet. An engineer's certificate was issued on the 29th of January 15, certifying to the project owner that he may terminate the employment of Intermas after giving 14 days' notice for failure to comply with its obligations under the contract. Intermas's response on the 3rd of February refuted the non-conformances highlighted in the engineer's certificate and described the engineer's opinion as partial and selective. Then you have a section strategy and action plan, and you report that you explained to the client, and that's Mr. Musabbah, is it?
Yes, indeed.
That NBAD does not recommend termination of Intermas, and that this will lead to stopping our finance. However, he seems to be moving towards termination of Intermas and Hill International. This, along with the reports that he met with Knight Frank last week, lead to the conclusion probably heading also to sell the project. We'll meet with the client this week to stress the bank's stance against termination of the main contractor and project manager, given the advanced stage of the project, 60% completed, and to get some visibility on the potential sale. And that was your stance, wasn't it? The bank was against the termination of Intermas.
Indeed, yes.
And that really remained your stance, didn't it, from now, at the beginning of February through to the termination of the facility in May.
And indeed, even if I may add, Your Honor, even if I'm requested for my recommendation currently in terms of substituting or changing a contractor on a project of this size, it will continue to be the same in terms of not recommending whether for this project or any other project to change the contractor at that level. And in the industry and in such project finance, whether project managers or surveyors of international renown would not recommend such a thing because it has huge implication on the project completion.
Go to bundle 12, please. And 194 or 195. Sorry, tab 194, but the second page of it, 2559. And I want to just touch on the second page with you. This report or memorandum, executive summary, contains 3 paragraphs on the second page referring to a meeting on the 23rd of February with Mr. Musaba al-Mahiri.
Yes.
That in the middle of the page. Now, is it fair to say again that at this meeting you made it clear to Mr. al-Mahiri that the bank was opposed to the termination of Intermas?
Indeed.
I think you know that Mr. Musaba does not accept that pending conditions subsequent or existing delays being a breach of the restructure agreement was said at the meeting. I think you probably heard him say that, did you, if you were in court?
Indeed, I heard him say this, and I confirm that this discussion took place at that meeting.
If we go on to page 200 in this bundle, please, tab 200. And if you turn on to page 2584, there's a case submittal form to the Chairman's office, again, in relation to this project, and another update. This is on the 10th of March. And if we look down the update bullet points, we can see the 5th bullet point. Noted over the last 3 months we had several meetings with all counterparties to resolve the disputed issues. 23rd of February we met with Mr. Musaba al-Mahiri in the presence of Sama Abdul Haq. Client reiterated that Intermas and Hill must be replaced to push the project forward. He provided a letter from Track Keys in relation to the licence. And then GGC, that's Mr. Samar Abdul Haq, isn't it?
Yes.
GGC General Counsel explained about his view on the contractor potentially getting a injunction, and essentially why the bank were against termination. But no mention there of conditions subsequent or delay being a breach of the restatement agreement.
So the question?
No, there was no mention there in this report to the Chairman's office of the conditions subsequent or the delays being a breach of the restatement agreement.
Well, indeed, whenever we submit to the Chairman, we try to keep it short in terms of a one-pager to send to him. And basically, we try not to repeat everything we said previously, otherwise it will run in several pages. So basically, we used to just put summaries in terms of what's happening. And at that period, actually, the point was that starting end of the year or beginning of 2015, this account, because of the amount which was involved, was under scrutiny from our external auditors, the central bank, in order to ascertain where we stand in terms of the completion of the project. And if you notice at the top, the subject, Das Real Estate, the rating of that account was not normal anymore, it was watch, reflecting the deterioration of the account, and we had very close follow-up also from all senior management within the bank in terms of where we stand, and this is why we would see that the meeting and the reporting on this case had intensified, and we couldn't repeat every time the same aspects. It's a continuation.
Go on to tab 206, please. And go to the page 2642. This is some emails which we'll need to work, as it were, backwards through. If you go to the bottom of page 2642, see that on March the 15th, you invited a number of people to a meeting on the 19th of March, and that was a meeting that included, notably, Mr. Al-Mohiri and Mr. Shuhaba of Intermats. That's the meeting you wanted to set up, wasn't it?
Yes.
Because what the bank wanted to do at this stage was to broker a solution to keep Intermas on the project.
No, we needed a solution as a bank to ensure completion of that project because of the amount which has been invested by the bank and which is actually 100% of the construction cost so far. And with the increasing requirement in terms of classification of this account, this became actually a requirement to see how we can find a solution. And as the solution at my level and my colleague Masalia was not anymore possible, since Jan, the senior management got involved in the details, like meeting with the legal counsel and also meeting that Mr. Moheri had with our CE, and the involvement of the chief risk officer as well as the chief credit officer to see how we can resolve the situation which is pending.
And then Mr. Al-Mohiri on the 16th of March, just above your email, he declines your invitation, doesn't he?
Indeed, yes.
And then we can see your what you do following that at the bottom of page 2641 is that you send an email to Mr. Dhabi Pjsc, who I think is your boss, isn't he? Or was?
Yes, if I may, Your Honor, at the beginning I was reporting organizationally to Mr. George Yezbik, the Chief Credit Officer. Then I reported starting February 2015 to the Chief Risk Officer, Mr. Abhijit Chaudhry. However, both were senior to me, and I reported to both of them.
Yes. So you're emailing Mr. Chowdhury here, who's, we can see at this time, as Group Chief Risk Officer.
Yes.
And you're saying, I will prepare a response for review by SEMA before I send.
Yes.
So that's a response to the email you've had from Mr. Al-Mohiri on the following page, is it?
Yes, indeed.
And for review by SAMA, that's Mr. Abdul Haq, General Counsel.
Yes,
right?
indeed.
And you say, for review by SAMA before I send, from the discussions I had with him yesterday, he's now adamant that he will issue a termination letter. So is that SAMA was adamant?
No, I believe that the I'm not sure if this refers to termination of the contract or no. It might be, yes.
It might be, you're not sure.
Whether this is termination of the contractor or the termination of the... I'm not sure if I'm referring to the discussion with Mr. Muhairi about the termination of the contractor in this instance.
That's how it struck me, but
Yes,
are you putting it to him that it's not Mr.
Well, I'm asking him for clarification, effectively, because it's
Yeah,
not...
this is-
It's inconceivable it's Mr. Seymour, isn't it?
I'm so sorry.
Then I misheard it. Okay.
It's just that I mean, grammatically, it would seem to refer to a discussion with Seymour the previous day. And the other thing, we know that you had a discussion with Mr. Al-Mahiri on the 14th of March, because there's a record of that, but the day before here is the 16th, and so that's why I'm asking for your clarification.
Yeah, I believe this refers to the termination of the contractor and Mr. Muhairi being adamant on the termination part.
Then if you look then at what happens next, you've said to your superior you'll prepare a response. The next email we've got, if we turn back to 2640, is one from Louise Flanagan, Senior Legal Counsel, to you and Ms. Shocker, and she's saying, "Hi, Antoine and Alia. Further to our conversation a very short while ago, and the conversation I understand you had with Sama earlier, I understand this analysis is very urgent and required immediately. Please therefore note that my review has been very high level indeed." And she says, "Please see below my thoughts on our ability to block the termination of the existing contractor and appointment of a new contractor." So was that what you'd asked her to think about? Was it how to block the termination of the contractor?
Well, from my recollection, the termination of the contractor actually posed an issue for us in terms of the completion of the contract, and we needed to see what are, from a legal perspective, what are the aspects, whether or not how to go forward with this case, noting that there is a requirement from the project owner to terminate the contractor, while from a contractual obligation under the restatement agreement, the contractor was, and the construction contract was part of the agreement with the bank. So this is where we were trying to see what we can do about that situation.
Yes, you wanted to block the termination of the existing contractor and you wanted your lawyer's help to do it. That was the position, wasn't it?
Yeah, the question was whether or not we can actually stop or not the change of the contractor or the termination of the contract actually.
Yeah, yes, but
Contractor.
You wanted to block the termination and you wanted legal help to do it. That's right, isn't it?
I don't believe I use in my email I refer to blocking, but yes, indeed, the termination of the contractor was something that we viewed negatively and which will affect the construction of the project and accordingly the repayment of the project and accordingly the interest of the bank.
It's not your email referring to blocking. I appreciate, Mr. Socken, but Flanagan says further to our conversation a very short while ago. So did you have a conversation with her?
Probably, yes.
And she says following that, and a conversation you had with Sama earlier, she understands this analysis is very urgent and required immediately. And then the next paragraph says, "See below my thoughts on our ability to block the termination of the existing contractor." So it does look as if
Yes.
that's what you'd asked her for, doesn't it?
It seems so.
Then if we go to the previous page again, at the top of the page you say it's very, well no, Mr. Samar Al-Haq I think says that's very helpful, Louise. Then if at the top of 2639 we can see a draft which from the bottom of 2638 appears to be your draft. that right? That's your draft that appears on page 2639.
I cannot recollect if this has been drafted by me in coordination with legal or did I receive it from legal.
Yeah. At the bottom of 2638, this draft appears to be in your email. You may have had it from someone else. It may not matter, Mr. Sokol. At all events, there was a draft within the bank that you were including in your email on March the 17th. And then there seems to be a process of getting approval from the chairman's office for this. If we look at, I think we can probably go to 2637. If we start at the bottom of the page, Mr. Chowdhury is asking you who will put it for you on letterhead and be signing it, and then you say it's done already. We're getting signature from business, as I do not have authorised signatory. And then Mr. Chowdhury says, please follow up with Sama. He told me last night he would speak to chairman, and then the letter to be released I've mentioned to Alex as well. Thanks. And then on the 18th of March, you are asking Sama, do we have clearance from the chairman to send? So clearance had to be obtained from the chairman of the bank to send this letter, did it?
Yes.
Why was that?
I cannot recollect the exact context, but usually in a situation like this where the chairman being the chair of the risk management committee of the board and where we have given him previous update on where we stand on the case, we usually refer just to have a clearance.
And then the letter is sent at divided 207 of this bundle, and it's the letter of the 18th of March. And we can see, if we just look, I think we're all fairly familiar with this letter now. You refer in the second paragraph to Mr. Al-Muhiri declining the invitation to the proposed meeting, and accordingly you cancel the same. At the bottom of the page you refer to the bank having consent rights. You refer to the fact that Hill had been terminated without consent as a breach of the agreement. Over the page you say the construction contract is assigned under the construction contract assignment, and if that becomes ineffective, further breach will occur. And then in the next paragraph you do refer to the development being at a standstill, and you understand that will lead to a further event of default given the obligation to procure development completion by March the 31st, 2014. 2014 will take as an error, but that's a first time that the bank puts in writing any reference to Mr. Al-Muhiri to an event of default for failing to procure development completion by March the 31st, isn't it?
I don't recollect all the correspondence, but this is indeed referring to that aspect. However, the date of March end 2015 for completion of the project was agreed and was part of the agreement with Mr. Muhiri to complete the project. And in fact, in terms of the repayment of the project, which was set in December 2015, the start of the repayment was based also on that date.
You referred to clauses about supply of information, and then you requested that Mr. Al-Muhiri meet with you and all relevant parties in order we put in place on a consensual basis a comprehensive plan to put the development back on track. And you wanted that in the next 5 days. So that again was you were wanting a meeting between DAS and Intermass, weren't you?
Indeed, and if I may say, as I said before, actually, that at that stage, the involvement we had, the legal department involved in drafting all these documents because of the situation that the case have reached. So basically, this is a document which had been drafted by the legal department.
Now, by this time, on the 18th of March, you'd been told by E.C. Harris, hadn't you, that the projected completion date was now the 31st of December 2015.
If I may, you're referring to...
Yes, if you turn on in this bundle, please, or actually back in the bundle, to tab 205. Where you see the Harris report for February 2015. And if you turn, please to page 2602, and at the bottom of the page you can see 115, absence of revised and consented programme. As informed by the engineer, the forecast main contract completion date is 31st December 2015, slipped over 1.5 months since the January report. So at the time that letter was written, you knew that the completion date was projected as 31st of December.
Obviously, it was the delays that happened. There were the reports on that date from E.C. Harris reflecting further delays in the completion date.
Yes, so you understood, didn't you, at this time in March, that the completion date was projected to be 31st December 2015?
Yeah, which is way beyond the date that was agreed in the restatement agreement to be as a completion date.
Yes, absolutely, and indeed, it was the date. It was already the date of the repayments to begin under the restatement agreement, wasn't it? Like to look at that? If you go to bundle 6, please. Go to bundle 6, tab 45, page 1083. There we can see the repayment dates under the loan agreement, and they began on the 31st of December 2015.
Indeed, yes.
And then if you go back to bundle 12, please, and tab 220. Your email of April the 20th, 2015, yes?
Yes.
And you attach a status of CPs and CSs for DAS.
Yes.
And you send that to Mr. Sama. And we can see over the page there is a schedule of conditions precedent, and then on the second page, conditions subsequent.
Yes.
So is that did you prepare this schedule?
No, actually, I requested one of my colleague in the team to prepare this based on the file.
Yes, you had someone. Okay, you had someone beneath you, a junior to you, investigate the file and prepare this schedule of outstanding matters. So prior to this date, it follows then that there was no such list in existence of outstanding.
I'm not sure about that. I usually don't follow the daily aspects of the account, knowing that we have several clients with different projects and different facilities. So I don't manage on the daily basis the file or the such
But you asked
activities.
for this to be prepared at this time, Mr. Sokhan, didn't you?
I asked for a summary, yes. Now, I am not sure what was, whether there were something similar in the file that was used to provide this. Was it this summary or another form of summary? I'm not sure.
But if we look at the front page of it, the 2714, we can see a date of April 2015 in the top right-hand corner. It looks like a document that's just been prepared, doesn't it?
But obviously, we put the date of the day where we prepared this document.
Yes. So it's at this stage that you prepare a list of the conditions subsequent that you regarded as outstanding.
Now, we prepared this list specifically for the purpose to send it to the legal department. However, the follow-up on the different conditions subsequent are reflected in the file and are was in a form or another, not necessarily this form, but the follow-up on the condition subsequents are actually something which we can find in the file and reproduce it in any form we want.
And then if you go on, please, to tab 223. That's dated the 22nd of April. To Mr. Al-Muhiri. And at this stage, we can see that, again, if you go to the third paragraph, you are asking Mr. Al-Muhiri to attend a meeting at which senior management of NBAD will attend along with the contractor. So again, as the 22nd of April, what you're pressing for is a meeting between and Intermass.
Yes, indeed. And if you note that this letter was actually signed by the CEO and the legal counsel, insisting on the importance of having a discussion to understand where we stand on the completion of the project and the situation of the contract.
And it was if Mr. Muhiri declined the invitation to meet with NBAD and the contractor that NBAD would be forced to take steps, is what's said in the next paragraph. It's if he doesn't meet with the contractor that steps will be taken.
Yes.
If I can take you next to bundle 13, please, Mr. Sokhan. And page 200 and tab 234. Which is an email from you to Mr. Yazbek and Mr. Abdel Haq on the 7th of May, copied to others. And you deal in the first with the question of the license. But then I wanted to ask you about the bottom half of this email, where you refer to our current exposure being 513 million. Including interest, with additional budgeted cost to completion of 230 million. And then you say the total cost of completion will probably increase to 800 million, to which will be added around 150 million in finance due to ongoing delays. So your costs in round numbers could be, or your exposure could be 950 million all in by the time the project is finished, including interest.
Potentially.
Whereas the property value on completion on the latest valuation you understood was 1.28 billion.
Yes.
So if, on that basis, if the project was allowed to complete, there was prospect of the bank being repaid and there being some equity left for the owner, wasn't there?
I disagree with this statement, and Your Honor, if I may elaborate on this point, I see that there are a lot of emphasis being put on a collateral value. The way we approached project financing of this nature is based more on the cash flow rather than the collateral value, and indeed the collateral value actually is based on the discounted cash flow of the project, which is the cash flow which will come from the rental of the hotel after the income of the hotel after the completion of the project. And this is why when we looked at the restructuring of this case, we had two risks involved. One is the completion risk, the other one was the repayment risk. And as long as the completion is not adhered to as per the timelines that we have set, obviously the value of the collateral upon completion, which is 1.28, will not be an actual value because there is no discounted cash flow coming from the hotel. And this is where our main concern was, from a financial perspective, it didn't seem feasible anymore to add more financing to this project because simply of the fact that even if it's completed in terms of construction, the income which will be produced will not be sufficient to deal with the burden of the debt itself.
As I understand this email, it's on the premise that you would actually fund the additional cost of 150 million.
Yeah, Your Honor, at that stage, actually, it was only a forecast. There were not even yet a certainty.
You would fund whatever was required to finish the project?
Yes.
More than you'd already learned, and something in the region of 150 million.
That was my personal forecast. My view, yes.
Yeah.
So at this stage, Mr. Sokran, the bank was prepared to go on supporting the project with Intermas as contractor, wasn't it?
Well, as I said before, it's whether for this project or any other project, we look at continuing performance of the contractor who has started the work, because if you change a contractor at the 60%, 65% completion, this will definitely involve different aspects which will be not only the cost escalation but also technical aspects which will be impact the construction or the project negatively. And this actually I referred to in my witness statement based on the EC Harris report, which actually explains what are the risks arising from changing the contractor at that stage. So yes, the bank has been always supportive of the project. We have tried as much as possible to support and to move forward with the completion of the project within a certain boundaries which were set within the restatement agreement.
Yes. And here, in this email, you are looking at going on with the project. You're looking at the numbers, big picture, if you go on with the project, aren't you?
This is not the case here in terms of what I have said. What I'm saying here is that there seems no more, the contact between the contractor and the project owner ceased to exist. We're not able to bring them to the table to discuss the issues. We have a project on site which is abundant. The main conditions that we have put for the project to be on track, which is project manager, is not anymore on site because the project owner didn't renew his contract. And with all the aspects that we have seen at that, I had seen at that stage, it was clear that the project will not proceed as it was.
To understand what you understand by the verb support. You supported this project, and as I understand it, you, correct me if I'm wrong, preferred, to put it no higher, that Intermas remained as the contractor and you
Exactly.
changed to another contractor, or your client didn't. You were supportive of the project, but by now, I think, the overall cost had increased by some 150 to 200 million dirhams. Was the extent of your support such as that you were disposed to advance a further 150 to 200 million?
Not at all, Your Honor. I wouldn't have recommended even for the project owner to
So
put
if the
it.
project was to be completed, finance would have to be found elsewhere.
Exactly.
What you're identifying in this email, Mr. Sokon, is that if the project was completed, there would be enough value in the completed project, firstly to repay the bank, wouldn't there?
No, this is not what I'm referring to in this email. Not at all. If I knew that that project would be having enough cash flow generated upon completion within the situation as of that date, I wouldn't be saying that the legal action seems to be the last resort, because otherwise I would have recommended to my senior management, Mr. George and Mr. Abhijit, an alternative which is different from what I'm setting there.
You understood, didn't you, that the claimant was dependent on bank finance to complete the project?
I'm sorry, I don't.
You understood, didn't you, that DAS was dependent on bank finance to complete the development?
Well, completion of the development was based on the restatement agreement within the set conditions that were there in that agreement, specifically with regard to completing within certain time the project. Now, beyond that date, I don't see how the solution would have been done and what would be expected from the bank in terms of financing, because there were no mean for the bank to be able to anymore add additional financing to this project.
And what I asked you was this, that you understood, didn't you, at the time, that DAS was dependent on bank finance to complete the project?
Yes, the bank has actually financed 100% of the construction cost as of that date.
And you also understood this, didn't you, that if bank finance was withdrawn, then DAS would be unlikely to be able to complete the project?
Definitely, if DAS doesn't provide their support to the project from an equity perspective, the project wouldn't be able to be completed.
What I asked you was that you understood, didn't you, that if the bank withdrew its finance, that DAS would be unlikely to be able to complete the project?
Yes.
And you also understand, don't you, that land can be worth less with a partially completed building than with no building at all?
Yes.
And so if the project, if bank finance was withdrawn and the project was not completed, then the potential value that could be created by that completion would be lost.
Can you please repeat the question?
Yes, if bank finance was withdrawn,
Yes.
and we've agreed it's then likely that the project would not be completed,
Yes.
then the result would be that the potential value in the project, the completed project, would be lost.
Can I intervene? I'm not sure that is a particularly helpful question, at least for me, because you're associating bank finance with this bank. And I can well see that if you've got an incomplete building and the owner has run out of money and he's reliant on bank finance, he will have to go to a bank to get more money. And that might be the bank he's already borrowing off, or another bank. So it seems to me the only, in a sense, value of the question I think you're asking is that if the owner runs out of money from his bank, he will have to, if he wants to finish, get more money from that bank or money from some other bank? To which the answer, no doubt, is yes. I'm not quite sure where it helps me.
It is relevant to a legal submission on UAE law.
Well, this is you're doing more damage to
Just
others
before-
than to
yes,
yourself, point,
yes,
is it?
yes.
Well, that's why it's so important to draw a distinction, it seems to me, between bank finance and finance from this bank.
Well, let me ask that then. Mr. Socken, you understood, didn't you, that if NBAD withdrew its finance for this project, that there was a risk that it was unlikely that the project would be completed?
Unless the borrower or the project owner bring his own finance or equity into the project, or alternatively another finance from another bank.
Yes, but we have already agreed, Mr. Socken, haven't we, that DAS was dependent on bank finance for this project?
Yes.
I don't understand why it's a necessary prerequisite to this question that this bank withdraws its finance. The question must be, if the bank did not cancel the loan, would the project have been finished? Which is a different question.
Yes.
Anyway, sounds all like argument to me.
It probably is. Yeah. It probably is. The decision to terminate Mr. Socken followed fairly shortly after this on the notice of demand we know was on the 21st of May. The decision, can I just explore with you who actually made the decision? We've got some guidance on it in this bundle at 2 tabs later. At 236. Because we can see there an email from Mr. Sama Abdel Haq to Louise Flanagan, and they're looking at the draft notice, and he's saying, I'm fine with the proposed form of notice acceleration as a decision for risk to make.
Yes.
So it was Risk Department's responsibility to make the decision to issue the termination of the notice.
Yes, and by risk, this refers to Mr. Abhijit Choudhury, the Group Chief Risk Officer, and Mr. George, the Chief Credit Officer.
And was it their decision then, in the end, to issue the notice of the 21st of May?
Yes, indeed. And in fact, this bundle refers to an email. However, at that date or during that period, this account was discussed on weekly basis with Mr. Abhijit Choudhury and with Mr. George Yazbek, which led actually to reach that conclusion on May 11, 2015.
Right. The decision was made by Mr. Yazbek and Mr. Choudhury.
Yes.
Yes. And they didn't take it to the Risk Management Committee, is that right?
No,
Why not?
because it is within their authority to actually issue a notice letter to protect the bank's interest.
Isn't it the normal procedure of the bank that decisions to terminate a facility would go to the RMC?
Not necessarily. In terms of approving a credit facility or increasing credit of facility, usually it does. However, when it comes to a situation which is to protect the bank interest, the chief risk officer of the bank has the ability to actually take that decision.
Now, I've got here, Mr. Socken, a public document from the bank's website. It's not in the bundle, but it's the bank's website document, which I'd like to just look at with you. So if copies could be produced, please. This is a document which has been printed from your bank's website. It's a Risk Management Committee Charter. I imagine you're familiar with this document, are you, Mr. Socken, as you're in the Risk Department?
I'm trying to refer to a date for this document, but
This was printed off overnight from the bank's website.
yes,
You are familiar with this, are you, Mr. Socken?
I am familiar with part of this document, though I'm not really sure which date this document has been issued, because these documents change from time to time.
I accept that. This is the current document, at least it currently appears on the bank's website.
Okay.
Could we look at paragraph 5.12, please? 5 pages in. See where we are. I can look back at the previous page and see we're under a heading of responsibilities of the committee. One of those responsibilities at 5.12 is to approve, ratify or review, as the committee considers appropriate, any transaction or other proposal that exceeds limits detailed in the risk authorities granted to the management, referred to in Annexure 2. In cases where it exceeds regulatory approvals, the bank will seek specific approvals from CBUAE. Is that CBUAE, is that the authorities?
This is Central Bank of UAE.
Yes. So, for approvals, ratification or reviews above the limits detailed in the authorities in Annexure 2, then it's a matter for the committee. Right?
Yes.
And if we go to Factors Appendix 2, 3 pages in from the end,
Yes.
we have the risk authority levels granted to GRC, and we can see head office authority levels, authority level 1, and risk levels for financial institutions and sovereigns. And then if we go to the page non-financial institutions, authority levels. And it's right, I assume, isn't it, that in dealing with the DAS account, that would be a non-financial institution?
Yes.
And so, isn't it right that the authority limit for a review would be 30 million dirhams?
Well, assuming the authority is 30 million there, however, as it states in the paragraph that you referred to it before, 5.12, the committee actually approve, ratifies, or review the decisions made by the management. So basically, even if the management takes a decision, the decision will be submitted later on to the committee for ratification. And this, if I remember well, happened actually in this case also, where the decision to take the legal action was actually ratified by the Board Risk Management Committee later on.
A document which has not been produced in these proceedings. Oh, no, I know it. We'll have to check that out. So anyway, your evidence is that it was approved by the RMC.
Yes, ratified by RMC.
Thank you, Mr. Socken. I have no more questions.
Where should we put this?
Shall we simply put it at the back of volume 15 for convenience?
Yeah, I'll hand it back. I won't receive the document, it has got a hole in it. Okay. Back of bundle 15, you say?
Back to bundle 15, yes, we'll
Yes, I'm sorry.
Just one re-examination question on the last point
Yes,
raised
sure.
by Mr. Thomas. If I could ask for Mr. Sutton to be given bundle 15, please. Tab 291. This is a note of a risk management committee decision on credit cases dating from 13 January 2016. And if you review that and turn over the page, you have WSAN comment and recommendation. And if you just read that, and if you just like to inform the court whether this is the document that you were referring to when Mr. Thomas asked you the last question on ratification.
So we're looking at page 3188, are we?
Yes.
Yeah, thank you.
So, Your Honor, its ratification of the aforementioned actions is recommended to safeguard MBAD's right in view of the current impasse, potentially lengthy litigation, and central bank examiners' directives to classify the account if a new restructure based on equity is not finalized by end of 2015. WSM will continue, which is Special Asset Management, will continue to report on the development. And this is indeed the document which we have submitted to the Risk Management Committee to ratify the management decision.
Refer you on also to the decision on page 1, which is also a summary. Noted, continue with legal action unless equity is injected. Group Chief Executive Officer to communicate this message to the client.
Sorry, I'm not quite sure where you're reading.
Sorry,
Oh, on the right-hand side?
Yes.
Yeah.
If I may, Your Honor, this is an extract of the decision of the Risk Management
Yes,
Committee.
thank you. Thank you very much. Have you
Further questions?
punched the document? Thank you. All right. Now, it's 10 to 5. What do you want to do?
I understand the next witness is coming in the morning anyway.
Okay, well, that, I won't say it's relief, but it's a relief. Thank you. Thank you very much for your help. We'll adjourn now until 10 o'clock. And I'll see you tomorrow morning. Thank you.
Rise.